On November 7, the Supreme Court upheld the 103rd Amendment to the Constitution, which provides 10% reservation for the so-called economically weaker sections or EWS. It is projected as a reservation for the economically poor, but the point is much debated about. A key reason is the Union government has defined EWS as those with an annual family income of less than 8 lakh rupees or those who own property below the limits set by it. So, what is this amendment all about and why is it triggering wide-ranging debate? The 103rd Amendment was enacted by amending Articles 15 and 16 of the Constitution. Article 15 prohibits discrimination on the basis of religion, race, caste, sex, or place of birth. Article 16 guarantees equal opportunity in matters of public employment. The amendment gave Parliament the power to make special laws for EWS similar to those made for SCs, STs, and OBCs. This amendment kicked in on January 1, 2019 and opened a provision for 10% reservation for EWS. This was different from the reservation given for BCs, SCs, and STs. It is applicable in higher educational institutions and initial recruitment in government jobs. The idea behind EWS goes back to before 2019. The UPA government had set up a commission headed by retired Major General S.R. Sinha in March 2005. The commission submitted its reports in July 2010. The Sinha Commission had recommended that all below poverty line families within the general category and families whose annual family income from all sources was below the taxable limit should be identified as EBCs, which is economically backward classes. The Commission, however, did not explicitly recommend EWS reservation. This perhaps explains why the centers moved to provide special reservation for those who are already socially privileged has drawn flack from large sections of the society. The Supreme Court judges who upheld the verdict on Monday maintained that since other disadvantaged groups are already benefiting from reservations, their exclusion from the EWS quota is not discriminatory. They insisted that EWS is consistent with the right to equality guaranteed under the Constitution. However, those against EWS point out that the 10% might violate the ceiling of 50% for all reservations fixed earlier by the court. They further say that excluding SC, ST, OBCs from the 10% EWS quota is violative of the equality principle. Justice K. Chandru, a former judge of the Madras High Court, writing for the Federal, observed, "There's nothing to be cheerful about as the caste here represents the upper castes of the society who initially opposed reservation on the grounds of merit but finally got themselves a new EWS quota which is not just disproportionate to their population, the fixation of the income ceiling enables them to overtake the OBCs who were excluded from reservation on the grounds of creamy layer but not considered under the EWS quota. Thus, the debate on caste over class continues to rage." A Federal report. Subscribe to the Federal's YouTube page for more interesting updates.